So welcome back to the afternoon session that will be devoted to a more, if I might say, a more practical perspective on the European Union Act and AI regulation in practice, with a also more focus on the Latvian case. So we will deal with the key implication that we can start foreseeing of the European Union Act that, as we already heard this morning, or we are reminded this morning, is already in force. And so we also how it will be, or it could be, or might be. So let's see how the panelists articulate this, the incorporate into the national legal framework, and also the type of compliance issues that may raise on the ethical level, risk assessment level, and alignment with other regulatory requirements. Okay, so how you can deal with that. I personally have been touched by this, by the way. So a few weeks ago, a news paper here in Latvia, in the online version, published a picture of me with a quote I didn't say. And so I don't know who is responsible, whether the newspaper or whatever model they have used, because that quote was not said by me. And by the way, I didn't know the quote. I mean, I didn't know what I know the topic because it's part of what I usually speak about, but I didn't have any foundation to say what they say I said. Okay. Now, the moderator will be Dr. Edgar Volskis, who is also a colleague of mine working for the Riga Business School, in teaching in many fields, but also working in our AI studio, will be introduced later, and also worked for BDO in Latvia. And then we will have, though Edgars will introduce them in more details, so Dr. Alessio Buscemi from the Luxembourg Institute of Science and Technology, Aiga Irmeja, a partner also of RBS from the Latvian IT cluster, Arturs Arnis Polikarpovs from the new ministry, so Ministry of Environmental Protection and Regional Development, Salmi Spielbergs from Alex Klavin, also very active on AI and heading the work group in the AmCham. And also another colleague of mine, Uldis Karlovskis, professors in Riga Business School, but also an entrepreneur. Okay, Edgars, the floor is yours.
Thank you, Claudio, for short introduction, and I'm really glad to be here and glad that we are having this chance to discuss AI, EU AI Act, and specifically with this great panel, which is together with me today, really to talk about practical implications, not just from legal perspective, but thinking on the business perspective. And as Claudio mentioned, I'm working at Riga Business School. I'm professor at economics, and there will be some things I'll be more concentrated on economics, because in the morning we've been concentrated so much on the legal stuff, but which was very useful also for me. And also, as Claudio mentioned, I'm a professional accountant for more than 26 years already, working for international accounting auditing firm BDO, and I'm leading advisory practice here in BDO Latvia. Before we'll start this discussion, I wanted to just refer to two things and remembering my economics classes and something what Claudio started today with. And I'm referring to your presentation, Matthias, where you mentioned if somebody, because I'm a numeric person, I always remember numbers. I like by my heart, sometimes I think that I can know all phone numbers in my phone. But when you mentioned this, that less than 10% of the companies in worldwide have been coming from EU that has been generators of AI tools, I was thinking, is it any indication for us that there is something is wrong? Because remember what Claudio told, everything starts with innovations. And when you take the economic development, not growth, not GDP formula, but economic development formula, one of the elements in this formula is investments in innovations. How much innovations do you develop? Is your market competitive then? And therefore, this number raised for me this discussion, thinking, okay, from one side we are so much concentrated on EU Act about this developing legislative framework, but then from other side, then we look on economic growth, development, and then we should ask to yourself, are we on the right direction here, EU? Are we competitive? It's not about the growth of economy in EU, but it's about development of economy, which are two different things. And this is something I want to dedicate today with my panel today in the discussion, how understanding and the experience what people had and what we have seen from regulatory perspective, from business perspective, are we going to the right direction? What challenges are, and probably what lessons are we can take from this, and what insights might come for us. And therefore, as Claudio already introduced, we have 5 great panelists representing a regulatory, legal profession, and I'm glad that also we are having practitioners as Aiga and Uldis. And also I'm great that we have Alessio today, who will share real life experience about such thing in Luxembourg, from engineering, from IT perspective. And somebody in the morning session spoke about sandboxes, because this is something what we are looking for, what we need. But then the question, how this regulatory framework will help for development of economy, or will start slowing it down? Will we be competitive with US, where we understood legislation is quite vague, and then we start balancing what we are thinking of. Which goes first, chicken or egg, business or legislation, legislation or business? And that's a dilemma we will talk here. So, and since we are also limited in time, and let's use this time effectively, because I'm recalling my first lecture about AI, when I was studying in US, the professor in US told, you need AI in your business only for 3 reasons. If it grows your revenues, it makes effective your costs, so you become more profitable, or your risk management framework becomes more effective. If you resolve these 3 things, then you need AI. If neither of these are resolved, then AI is just a toy. Let's admit this. So, and probably if I may, I would give first floor to Arturs. And Arturs, as was mentioned, he has been working lately in Ministry of Smart and Administration and Regional Development in Digital Policy Department. And he has been the one, we are luckily, who knows EU AI Act by heart. Yeah, we had a discussion with him, whenever I talk him, okay, that's a chapter, this one, that's a chapter, this one, And this is a really, but what I wanted to ask him, if Arturs, you could give us a framework about EU AI Act, but looking from the, let's say, regulatory or governance perspective here in Latvia. What is it about? What should we be prepared for as business?
Yeah, thank you. Thank you, dear colleagues, distinguished guests, and everyone joining us online. My name is Arturs Polkarpovs. I work in the Ministry of Smart Administration and Regional Development, and let me take a moment to share a few words about AI Act and just to give us some common ground. On 1st of August 2024, the AI Act entered into force. It established the harmonized rules across member states and become fully applicable by 2nd August 2026. Some provisions take effect earlier, like prohibited practices from February 2nd this year, while obligations for certain high-risk systems will be phased until 2027. It's Annex 1. The Act goal is to strengthen the EU internal market, foster trustworthy human-centric AI, and protect health, safety, and fundamental rights. It also has extra-terrestrial scope, applying to non-EU companies placing AI on EU market, much like its GDPR. It strikes a balance between regulation and innovation, excluding research-only systems, testing before market release, AI systems used exclusively for military, defense, or national security purposes, personal non-professional use, and open source AI, unless such systems fall under high risk or prohibited practices categories and so on. So yeah, AI Act is has a risk-based approach. The first layer or level prohibited practices in force from 2nd February this year. Bans on AI systems that manipulates, exploits vulnerabilities like age, disability, social or economic status, and so on. The second one is high-risk AI systems in force from 2026 or 27, depends on Annex 3 or Annex 1. Strict requirements on data governance, documentation, technical, human oversight, cybersecurity, CE marking, and so on applies to systems such as biometrics, critical infrastructure, border control, or those requiring third-party conformity assessment under EU law. The next one is transparency obligations, for example, disclosing when images, audio, or video are artificially generated, like deepfakes. Additional, we can add general purpose artificial intelligence in force from August this year. Specific rules and codes of practice covering transparency, copyrights, safety, and security. And minimal risk, its majority of application remains unregulated. About these AI regulatory sandboxes, member states must set at least one sandbox by August 2026 to provide legal certainty, foster innovation, support SMEs, startups, and allow the real-world supervised testing. In previous session, we have like question about this governance model. We with gentlemen already discussed it. From governments, this framework, and EU level, we have European AI Office, supported by AI Board, scientific panel, advisory forum, and leads coordination and oversight, especially for GPI. At national level, we have like AI policy authority, it's VARM, our ministry. Ministry of Economics is notifying authority. LATAC is a national accreditation body. Ombudsman is fundamental rights authority, and market surveillance authorities. Each sector, all like that's is responsible for their competencies, DSA, and so on, so on, so on. And last but not least, about penalties, few words. Penalties up to 35 million. 5% of global turnover for prohibited practices, 50 million, 3% non-compliance with operator or notifying body rules, and 7.5 million on 1% of global turnover misleading or incomplete information to authorities. In few words.
Okay.
Thank you.
Thank you, Arturs. But if you notice, when I'm not a lawyer, but lawyers has been probably hearing, these risks, sanctions, restrictions, and when we start thinking, okay, it's EU Act, we are talking about restrictions, And then I wanted to pass a word to Sarmis Spielbergs, who is a partner in Alex Kļaviņš partner office. But he has been working really a lot with IT companies, with tech companies. What I'm reading here, he has 20 years of experience. And then, Sarmis, I wanted to ask you, by hearing this, what Arnis has told, to us, Arturs what told to us, what do you think? What might be the legal implications? What businesses should expect, or challenge, or put in the risk management framework, to ensure they are compliant, but still consider that they can grow and develop their business. And this would be, what would be your overview on this, because for me it sounded you cannot do this, you cannot do this is a risk, this is a restriction, that's the penalty. Where the business is in the end of it. Yeah, sorry.
Okay.
Sarmis.
So, my name has been said already a few times, so I will not introduce myself again. Yes, so the AI Act, that's a EU instrument. Obviously, Obviously, there's not much you can do about it on national level. EU has agreed in general that this would be the set of rules that the companies should operate by, and basically you kind of have to accept it. There can be a policy discussion whether it's a good thing to regulate or not regulate at all. I don't think the complete unregulation, as if you could say that in US at the moment, that would stay that way. I believe that they would also not accept the practices that we have in the EU Act as the prohibited practices. So, but probably through different means. So they would also go towards some form of regulation, whether it's self-regulation or whatever. But some rules will be put in place in any case. Even China is asking their AI systems to be trained in a politically correct manner, so everybody is doing something. And yes, so what my first feelings are here are it's sort of similar to the sentiment that the GDPR brought back in 2018. It was also something that everybody was afraid of. These big penalties in millions. You have to have GDPR audits, internal documentation, and all everybody's arguing, oh, this is going to be nightmare to comply with, and it's such a burden. Why are we doing this? Let's basically. I heard from industry that basically let's stick with the old directive, which is implemented in various member states in different manners, and just try to enforce that. We don't need the GDPR, but in Latvia, at least, what we see in practice, it's not as crazy, let's say. So the fines may have increased a little bit, but overall, we never hear from Latvian authority a fine of a couple €100 million coming out. So, and the authority is indeed in Latvia applying this consult first principle. If you are actually a small company and you are cooperating with them, in practice, it's not such a big problem that you are facing restriction, and penalty right away. So it is not as bad. Maybe the sentiment that it's going to be the end of the world and you can't do anything. That's, I think, a bit of exaggeration. When we move to AI Act closely now, as it was said already, it comes into effect in phases. So the penalties will not become effective until next year. So in terms of client work, we don't see yet such high demand and early morning calls as to what should I do? I will get the fine tomorrow. So that's still along the way to come probably. And most businesses will probably be using something off the shelf, ready-made, and thus as a user, you're probably not really exposed to too much risks. If you start modifying and adopting something yourself, then yes, you should start thinking about it, what you're doing. Then you might want to consult a lawyer or AI, I don't know. So what are your actual rights, obligations, and so on? But yes, so it is for us as lawyers. It is also an impact, of course. It's just partly a joke that I say that you can ask AI now anything. So yes, you can also ask legal questions and get, to be honest, quite correct answers. Sometimes there are hallucinations, but sometimes they are pretty much along the right lines. So and of course. Our clients also expect that we will, as lawyers, become more effective by using AI tools. That's something that in fee proposals we see that they are asking is show us what you do, what AI systems you use to be more efficient and cost effective. So it's impacting also us. But yes, overall, I don't see, I don't know, too much of a stress. But obviously, we also note that there is the big tech industry is opposing this. They don't like it, mostly probably because they don't have the same set of rules in the countries where they come from. This is something additional that they have to do it. Naturally, they don't like it. But yeah, it was the same story with GDPR. They also didn't face the same rules in those countries and were trying to lobby against it. But some kind of system and order has to be in place. I believe in that. Whether we have gone too far or not, time will tell. Obviously, the most concerned operations are related to this high-risk AI systems, where it's the annex, where the commission can supplement and still advise. So that's a bit of a blur yet. So that creates a bit of an uncertainty. The guidances have to come from the national authorities as to how and what, and then we'll also see the actual practice of applying those formally, possibly high penalties. But my feeling is that the national authority, in case if it's the data protection authority, we won't be seeing those millions of fines. So that's too much of an exaggeration. So that's my. I don't know if I answered your question, but.
Oh, you gave us some relief. There is, great opportunity, and I would like to pass, if you might pass microphone to Aiga and all these who are actually practitioners. And first, if I may ask Aiga, because Aiga is chair at Latvian IT cluster, and she's a coordinator at European Digital Innovation Hub. And she is a great supporter of development of technologies, especially in AI area. And as RBS, we can be thankful to her that she was one of the supporters for establishing at Riga Business School AI Studio, where myself I'm working in, and I'm excited about this. And if Aiga might share, from practical experience, talking, okay, that's EU Act coming. These will be requirements, these are the risks. But today, where the, let's say, business is business prepared for this? Do they see these risks, or they see more opportunities for grow and develop? What is really experience in the market today?
Okay, thank you very much for giving the floor and the opportunity to be here. So yes, from my one hat is being representative organization from IT industry, meaning that we are working with IT companies. So we kind of know what they are thinking and what they are doing, and also some development progress, and especially how AI software and AI systems are being developed more and more. And basically now every IT company who does some development work works with AI. But from the other side, we are also working with end customers, with end users. And as a European Digital Innovation Hub, our mission is to help users start digitalization, start their digital transformation journey. And of course, we are focusing a lot on AI. So basically we see two sides, the development side and also the user side. But I would like to second Sarmi's opinion about that. Currently, we see no big stress in neither of customer groups. So if we speak about developers, IT developers, then of course, majority of them falls into the category of unregulated AI. So they are stress-free. Yes, there are also a couple of cases in Latvia where we see which might fall under some risk category. And those companies are aware of that, and they are trying to deal and discussing what to do with their solutions. Are they going out of market, or are they trying somehow to, I don't know, fight their way and to convince that this is ethically correct way? As for users, I think there is a lot of things to discuss in future, because currently there is zero awareness about AI Act. And if we look at EU goals, and let me remind you that there is a digital decade goals 2030 that says that 75% of all European companies are using either AI or big data or cloud solutions, and using them meaningfully for the core processes. So 75%, that's almost like everyone. And if this mass of companies will start using AI without knowing what is AI, so we are in quite a big danger. So.
Okay, thank you. And then, if we may continue with all this is like entrepreneur, and he's like I would say has been working a lot in development, has worked with on development of chat boxes, which is an AI tool already. If all this you can share with us, what is your experience, views, expectations like from entrepreneur, from this perspective?
Mm-hmm. I think I need to first of all declare that between my many layers, first of all, I'm a humble engineer. You know, that was not supposed to be a joke. Okay, all right. But yeah, I first play and then I ask what are the rules. That's what engineers do. And then if we look at the AI Act, I did spend about 3 hours on the whole book. Right now, a question to everyone. Who has spent more than 3 hours on reading the AI Act here?
Lawyers.
Okay. Yeah. Well, I'm not a lawyer, but yeah, in 3 hours I was able kind of to get the idea. And then I was thinking to myself, of course, what does it mean now? One big learning which I got is that it's not even about those restricted systems. It's about all the AI systems that you cannot, you should not, you shall not, whatever is the right form in English, in any way try to impact people behavior with AI. That grabbed my attention. And that means that, for example, if someone comes to my office, I do have an office, that counts. And there's a concrete case. A few weeks ago, someone came in and said, I want to build this AI system. It's going to be to help people train better, train faster, to understand how well each of them is trained. We could make them chat with bots, and then we will assess what they are chatting about, and we will make a decision how good they are, and this way put them in some levels and suggest them things. And I was like, wait, wait, this sounds super cool, but this could be prohibited. Yeah, and the person was like, it was a normal business person. The person was like, why? What do you mean? Everyone does that in different ways. But with AI, yeah, it's kind of in one of the big things in AI Act. Another thing which caught my attention was, okay, if you do have this high-risk system, then you need to have this red button, how to turn off AI with a single click. And I, as engineer, was thinking, yeah, good luck with that. For a big corporate and enterprise system, having a red button, which if someone accidentally clicks, it turns off AI. I want to see who's going to do that and how exactly. So yeah, those things kind of came into my head. But then if we look at Latvia and what's going on now, then we engineers hear about AI Act. We have learned the most important things, most of us, I believe so. We don't really talk about it much at the dinner table because no one has got that fine yet. No one has even got a call, show us your AI yet. So we'll be worried when someone starts making those calls. It's not that we're doing the wrong things now, but we're just not thinking about it much. And I think that's okay for now. Except pushing your private data to OpenAI.
Okay, thank you. All this that's an experience, and understanding where we are. But now, Alessio, from all hearing this, going from what current legislative status is, what Artur's told that each member state should have established by certain date regulatory AI sandbox, and you have already experience in Luxembourg, working in your institute, and being AI engineer. If you might share your experience, how you have considered these restrictions, regulations from AI Act or these requirements, and how have you managed, and what is probably your success, and maybe what challenges you had, and what challenges do you see ahead?
Okay, first of all, thank you for having me here, for inviting me. So coming from a different country, we also have our own peculiarities. In particular, I heard now that in Latvia, businesses are not very concerned. I would say also SMEs and startups in Luxembourg are not aware and not concerned. But a big chunk of Luxembourg economy is banking, insurance, law firms, and so on. So their default expectations is that their services will be falling under the high risk. So yes, they are concerned, and they have the resources also to act on time. Whenever I go and I do a presentation, I always bring this plot from Google Trends when GDPR came into force. So there were 2 years for companies to adopt. And the Google searches of GDPR skyrocketed a few weeks before, meaning that a lot of companies then just rushed to the end, paid huge amounts to consultants and so on. So we can expect this to happen also before summer next year, I guess. Said so, at least I work on AI technical sandbox, which is not the regulatory one. I want to stress this, but our goal is also to support the regulatory one. What does it mean? So we have identified that there are two necessities. The first one is to checks internal controls of companies, and this means that all the processes are good and they are compliant with the law. And this is very similar to what happens already with the GDPR. That's why there is a lot of misconception, and that a lot of people, when talking about the Act, always draw the parallelism with the GDPR. But there is also another component, I believe, that does not belong to the GDPR, is that these systems are not deterministic. We are talking about generative AI mostly, even though the AI Act covers all systems. And this means that there are emerging behaviors. And these emerging behaviors are honestly worrying. For instance, a new paper from July showed that they can pass information from a bigger model to a smaller model in a way that is unintelligible for a human. So they can basically have their own code to transfer information, which is very worrying because it's completely out of human control. So these emerging behaviors somehow needs to be assessed and observed, right? And for this, the regulator itself does not have the competencies. So they will need technical expertise for that. And this is where technical experts are needed. Do we have enough technical experts? Probably not. Do we need to build these competencies? Yes. So this is what also we are trying to do, awareness and trying to put everyone on the same page. So regarding the experience with our industrial and public partners, so at the moment we have started projects with a bank, and the bank understands very well what are the implications for its AI system, and so they want to anticipate. So they want to arrive on the 2nd of August next year, prepare, because they don't want to expose a chatbot to customers that gives bias, for instance, opinions on credit, loans, and so on. The city we are collaborating with also was concerned that the citizens could be discriminated. For instance, let's say Luxembourg is very international, and therefore multilingualism and diversity are a real concern. And so the city is worried that if I go, for instance, asking for social housing, that I will provide different information based on your identity. And this is serious because, of course, has also legal implications. And then we have a company, which is a startup for recruitment, and they are also high-risk case. And differently from the other two that were mostly linked to, I want to prevent damages to my reputation as well as fines, the startup was more proactive, saying that we want to deliver a product that is more trustworthy compared to the competition. And I think they really got the point that was one of the main intents of this AI Act, which is to enforce European companies to provide a higher quality compared to the competition. because at the end of the day, we cannot rely on huge resources like the US and China. So I read this morning before coming here that Trump announced that Meta will invest 50 billion on a data center. So just one company, 50 billion, which is unthinkable in Europe. So we need to think in a different way. We don't have these resources, especially energy. And we need to invest in services and on frugal AI as well. So what will differentiate our products is the trustworthiness of them. This includes also all the ethical implications, fairness, robustness, and so on. So it's not only enforcing fines and make sure that AI is safe, but it's also a strategic choice to make European companies more competitive. Because at the moment we are lagging behind. So if we want to catch up, we need to find our, let's say, niche. And I think at the moment this message is not very clear. But I hope that through raising awareness and, let's say, redirecting efforts in the right way, companies, regulators will also understand that. So we can go in an harmonized way.
Yes, Alessio, thank you. And I think you raised very, very important thing. And I would like if you might pass microphone to Aiga. And I have a question to her in this matter. Specifically, you raised these two things. Again, going back where I started today, when you start thinking on the development of economy, not growth, we are not talking GDP. Remember, I talk about innovations, which are technologies, but then there are two important elements, which are labor resources, trained resources, and availability of capital. And my question to you, Aiga, is, since I presented you that you are the one and your organization who is really supporting development of these technologies. What do you believe? Do we have sufficient knowledge, resources, equity, capital available, let's say, to consider that, in the future, these innovations, technologies, like all these companies, might develop and grow in the future? Or what we are lacking today, and where should we put real emphasis here in Latvia? Either these as SMEs, NGOs, or some other, types of companies. So,
okay, I will not give a comment about like equity or funding in terms of investment, but I can give a comment in terms of competence. And I believe that there will never be enough competence. So we always have a room to grow. And specifically, if we speak about competence of end user, competence of the customer. And again, going back to my previous statements, that 75% of all companies will be using, hopefully, AI or other innovative or advanced technologies. And while using it, customers should be educated. Customers should be aware what is AI, what exactly is this technology, how does it work, and when we discuss customer being competent, it means not only like head of IT department. It means like every employee, or literally every employee, should be aware what is this technology and how does it at least in a very simple way, how does it work? And so otherwise we might be in quite a big trouble. So again, maybe going in some practical issues more deeper. Even now, when companies are using software, like especially when it's custom development, so in quite many cases, companies as a customers are lacking software documentation. Yeah, it's even like they don't have documented how their, for example, website is built. And when AI will come into your picture, so where are we going? Customers should be educated enough to demand from their suppliers to provide full documentation and to understand what they are demanding, and be educated enough to check that they receive everything needed, also for legal purposes.
Okay. And who would you think would be this, when you say educated, training, who would be the ones who provide this training,
Oh, certainly. So we have so many higher educational institutions who could do this. Riga
Okay,
Business
so
School, yeah,
meaning,
sure.
that it should be part of curriculum.
Yes,
yeah,
absolutely, absolutely. So curriculum, also vocational education should certainly be even more stronger and push more stronger.
Okay, okay. Okay, then probably going forward on, since we went this first round through, I would like, Artur, to you, since you are coming from government perspective, okay, you just presented us, told what AI Act is about, what should we expect, what are restrictions, but then, we heard that still there are, let's say, what Sarmis told, it's not so dark, there is still great opportunities, but hearing what the comments came from that side and listening to Alessio, what probably you would see the, let's say, next steps from governance perspective, from government to ensure that we implement EU Act smoothly and we see more opportunities in it instead of restrictions.
Yeah. If I may, I can also answer to comments and questions about these fines. It's Article 99. Just for information and
He knows
your
this.
knowledge, yeah. As you mentioned correctly, that give me a second, please. Yeah. So paragraph 7. So when market surveillance authority deciding whether to impose these administrative fines and so on, they should look an individual case and all relevant circumstances of specific situation, for example, the nature, gravity, and duration of infringement, whether another maybe institution find them already, and so on. So it's true, they will look at many aspects, not just to give the maximum amount of fines. About these prohibited practices, but Uldis mentioned that it's only when it's harmful, when it's harmful to person or group of person, then it's only prohibited. When it's in good way developed, it's okay. You can do it. It's not prohibited practices. And you should look at also techniques, what is used, manual, deceptive, subliminal, and so on, so on, so on. So yeah, and about also the education, also AI Act says this requirement provision that's written in Article 4, that's illiteracy. Yeah. Okay, and for the question about how we see from public administration, so we prepared this informative report in 2025 in cooperation with other ministries to outline the current situation and the requirements that's set out in AI Act and actions the public institutions must take to ensure its national implementation, such as responsible institutions, as in few words I already tell you about this governance framework, requirement amendments to national legislations and necessary resources for implementation. Okay, there's like I could say gap because as you know, we have great neighbor, and in fiscal policy 2026-29, all the resources go to demography and defense. So it's an issue, but we are trying really hard from ministry to solve it. And yeah, for the innovation, there's a requirement, as I already mentioned, from next year to develop this AI sandbox, as you already work in technical environment. From EU Act perspective, it's more like regulatory-based sandbox. But yeah, from Latvian side, we approach, as it mentioned in EU Act, that we need to build at least one. The authorities is market surveillance authorities, because from informative report which we developed, that these are authorities with these correct competencies. And yeah, come on.
Okay. So this.
So back to prohibited. A quick question. Let's test this. So let's say I developed a solution which we're going back to my story. I developed a solution which, let's say, for my company, assesses which employees are below performance and suggests that I should fire them. And I do fire 5% because we're in financial trouble. We don't really have time to analyze it, and AI told us so. So we're good. Is this harm or not?
Okay, let's separate two things. I will try my best. I'm not the one who will give the final answer, but I know a lot. Okay. As you mentioned, okay, one additional question. Will you use like biometrics maybe, or how you define?
How much budget do I have? Speaking like an engineer. No, let's say based on chats, but in the chats we can assess emotions, right? Yeah, pretty much. And the level of knowledge, whatever that means when AI tries to assess the level of knowledge based on words, not on A, B, C, or D, kind of based on context, when AI doesn't really have brains.
Okay, and the last question: will you decide the final, how to say, decision? Or
No, we will automate it. We're engineers. We will say, oh, you say these 5% are below? Okay, let's fire.
Okay, if you decide, from my perspective, if it, in such situation, so it is not prohibited, it is high risk. But in the second, I need to think a little longer. Sorry.
But yeah.
It's a problem of Article 22 of the GDPR.
See. That's
Okay.
Here
I will
is-
get in other trouble. Great.
Another trouble with this one. But thank you for this debate. That was interesting and useful. And here I have a question to Alessio. Yes, since you have worked with the sandbox already, you worked really and developed certain AI solutions. But when we look on EU AI Act and these high-risk tools, high-risk solutions, can you give us maybe some example from your experience that you really classified certain solution that this is a high risk when we, let's say, and would qualify this as a high risk in accordance with the EU AI Act?
So
Maybe
as
you can share some experience, like real life experience.
So at the moment, we do not provide this classification to say, like, for sure you are high risk, because we are following closely what are the regulators' activities, and they are the most qualified to do this assessment. For the use cases that have been presented to us, based on what is our interpretation of the Act, they were high risk, especially whenever you have a chatbot that is handling, let's say, essential services, such as, again, access to credit or inquiries about housing or other topics in a city. Then we consider this high risk, because the risk of discrimination is it's pretty high. As well as the fact that there needs to be, for sure, a lot of security measures to be put in place. So what I always say to companies, to make them better understand, is that what is regulated is not the technology itself, because you can have the same model. Let's say we mentioned before Meta Llama's models, but according to the use case, this same technology can become high risk or another level of risk. So to pay very much attention to why you want to use it, who are going to be the people interacting with your model, what are the implications if you have done your risk assessment properly, and so on. So yeah, did this answer your question?
Yes, yes, thank you. Now, since we have 10 minutes left before we go to Q&A, what you have had in the morning session now really on this discussion on these practical implications, opportunities, challenges. What would be for each of you probably 2 takeaways or insights for business and maybe existing and future regulators and regulations, to ensure that we implement EU AI Act, but we implement from consideration, okay, that's for tool for business development, for development of economy. So each of you, if you might spend 3 to 4 minutes on your 2 takeaways, insights. Who would like to start?
I can, as always.
As
I
always.
will briefly just, AI Act should not be seen as a checklist, but as catalyst. Government needs to build a supportive ecosystem, not just this enforcement tool. And SMEs, NGOs, and so on need to see themselves not only as rule takers, but also the co-creators of trustworthy AI, to build this trustworthy AI in the European Union. Yeah.
I guess this just echoes the same in different words, but from my perspective, I think it's very crucial to find the right people who are running the sandboxes. Companies who will come up with new ideas for new solutions. Will probably want to try to run through the sandbox first, and whatever the operators of the sandbox will say will probably influence whether they put it on the market or not. So if we want to foster innovation, then we need to have liberal people on those committees who say that, yeah, let's not be very risk averse and basically prohibit everything. Let's say, yeah, this maybe is borderline. Maybe let's take a little of risks and so on. So, yeah, it's pretty much it's relevant what people are put in charge of sort of overseeing and enforcing the AI Act, and how brave they are in the application. And
So my takeaway number 1 will be about awareness. So definitely information about AI Act is absolutely enough. So there's lots of information, and only if you want to learn anything, so you can do it. Of course, awareness is very low, and we must discuss more, but in order to bring up awareness like in a mass, so we certainly need to discuss particular cases, and maybe at one point of time when there will be some penalties, not maybe necessarily in Latvia, but maybe somewhere in Europe, then awareness will raise. My second takeaway will be for companies who are using software, who are using AI, start doing AI inventory. So, and for those in audience who are maybe old enough to remember 20, 30 years ago, the huge issue in industry was software asset management, like taking care of software compliance. Am I using software like according to a copyright law, like Berne Convention, maybe you know? And nowadays, I think history repeats itself, and we should discuss again about AI inventory. What exactly my company, my organization is using in terms of AI.
Thank you. All this.
Okay. This is probably going to be kind of a cry in a big black nothing. Yeah? But so for regulators, if we look at how things are done today, and I suppose everywhere, but kind of for the last 2 years, my outlook is very local to Latvia, I mean. And then, so how regulation works? Someone makes a law, people do something, and then someone catches them, and the fine comes. How does it look from the regulator's point of view? We translated EU regulation. We told people about it by publishing it on our website. Then some great people go outside and tell it at some conferences like Arthur's. Yesterday evening, we were kind of exchanging information. I was watching where is he going and telling about these things, but that's somewhat kind of his personal effort as well. And then back to regulators, they've done their job, and now it's time to catch the bad guys. And then most probably they complain that there's so many bad guys that they can't catch all of them, and now it's too much work and they need more funding to catch more bad guys. And it's like somewhat a never-ending cycle. I'm happy that some of you are having fun from this. Yeah. So, what is the purpose of public service? To service the public, and then we are paying our taxes to get some service, not to get fines, I hope, generally. If we turn this around a little, I, as an entrepreneur, as a business owner, I would like to be, I'm a picky one, yeah, I like to cherry pick. I would like to receive tailored information for me as a business owner, which applies to me, to my size of business, to my industry. Like, hey, here's AI Act, and these particular things may apply to you. Here, read about them in a not in a 400 pages document. Something short, something concise. If you want to know more, go read there. I would like to receive that message in my email, in my mailbox. So people in Latvia, do we have such options today? We do, technologically wise, we do. We have Business Go, we have Latvia LV. The information is out there, just need to use them. The business owners, now I can speak from my experience, gets a message from government to that channel like once per 2 months, and it's something, it's not tailored, it's something general. That channel could be super strong to talk with business owners. So that could be something to use, and most of it can be automated. And then, well, if I, as a business owner, could chat back to the government, hey, do I need to learn about AI Act? And it would ask me automatically over the chatbot, hey, tell me about your business. I would tell them about my business, and with simple LLM, it would tell me paragraph 7. I know I'm wrong. Paragraph 7 is exactly the thing which you should read. And I would do it because now it's tailored for me. So I hope we will have that in a year or 2 years or 3 years. Yeah, but AI can write its own code.
Okay, thank you, Aldis. No worries. Alice, for you coming from Luxembourg and experience, what you would say for Latvian society, and maybe still for, let's say, for other regulators in EU and even your regulator?
So I think all this anticipated me expressing a lot of concepts, but the core idea here is that communication should be improved. And I find it very funny because AI has been around for 40 years, but the hype is now. And why the hype is now? Because finally non-technical people can communicate with the AI. Before, it was seen as something that was reserved only for engineers, researchers, and so on. But now that we can communicate like a real person, we are using it, and we are hyping about it. So we find easier to communicate to a machine rather to someone with a different background and a different expertise. So my general recommendation for regulators and companies, technical experts, is to make an effort to be multidisciplinary in order to find the right words to communicate concepts efficiently, and also not to be in their own bubble. Because as all this also mentioned, there should be two types of communication. top down from institutions to the companies and organizations, but also bottom up from organization and companies to regulators, because the regulators needs to be updated on what is the state of the art, what is going around, and so on. So for regulatory sandboxes, this is actually one of the objectives. So catching early on in development, the European Commission, but also national regulators, can be informed of new technologies, new services, and so on. And this will likely fall also in gray areas of the AI Act, because whenever I develop a new technology, especially when we are talking about AI, which has a lot of emerging behaviors, then it would be difficult to classify in, according to the law. So in order to make the law more efficient, the information should be shared in a timely way. So again, my recommendation is to build multidisciplinary skills, both sides, and to improve by a lot communication, because otherwise wrong messages are passed or not passed at all. Thanks.
Okay. Yeah, thank you, Alessio. Thank you. Really, I wrote down 10 good insights from you, and then probably we can discuss this later on among ourselves. And we have representatives from business, regulations, and other representatives. We were exact in the time, real respect. And now we have 15 minutes for Q&A. And from the things what you have heard and discussed, we would be glad to have your questions, and our colleagues would answer to them. So there is a question, please.
Hi, thank you for interesting discussion. I have one question to Mr. Karlovskis, or maybe to Mr. Polikarpovs, about your mentioned example on firing employees using AI tool. Who will bear the final legal responsibility for such a decision?
The employer is the one who is responsible for observing the labor law, so you can't, the AI just can suggest which ones are the candidates, but then whether the termination was legal or not, that's a matter to be assessed under the labor law. So, and AI is not something that gives you an excuse, because AI told me to fire this one, that I can do it. So yeah, it's the employer still responsible. The board, actually.
Thank you.
But still, if I allowed it to do harm, then I will, as a buy, it's not a product, buy harm, buy harm, that's a new word, then I will get a double fine for misusing the AI.
Thank you.
Okay. Yeah.
My question is directed towards Mr. Spielbergs. At the beginning of the presentation, you mentioned a consult first approach for the enforcement or governing bodies. Is this approach legally binding? Is it written in some sort of act or included in AI Act, or is it some in form of some sort of guidelines?
That's certainly not in the AI Act. It's something that is in national legislation, and that's a good practice under administrative law that you don't fine. It's that you first advise and ask to comply. It's some governmental bodies have picked it up and adhere by it. So some may, even policemen might first warn you for speeding and then officially fine you. So yeah, it's a principle in national law how the enforcement is done of various laws. It's not a AI Act that introduces this as something novel. But the Data Protection Authority is really following this. If you look at their annual reports, they say that they have had hundreds of cases, but only 20 fines issued, for example. So that means that in most cases, they just managed to get the company to comply on a voluntary basis. So through just telling them that, hey, you need this, please do it by then. And most who do, they don't maybe get a warning, but no fine. If you don't respond at all and don't interact, then you're likely to get a fine. So that's the, I guess, the good practice. That's why we don't see the hundreds of millions of fines here.
And from the civil law perspective, if we talk about torts and damages that could arise from the AI use, what kind of liability model you see would be most likely applied in Latvia? Because there are different liability models, like strict liability, and there's a hazardous, like atomic, I don't know, enterprises. Then there's a different model for board members in Latvia that also has a different liability, let's say, model.
Well, you can never sort of blame AI. There's somebody who developed that AI. They will most likely have in their terms and conditions that, well, use it at your own discretion. We're not liable for the output. If you get some AI developer to say, oh, I guarantee that this is going to be always 100% sure, you can rely, good for you. I don't think that's really going to happen. But so I can say from my perspective, we as a law firm, we can use AI to do research, but that doesn't mean that the client won't be able to sue us and we will be able to say, hey, AI told me to, so go against them. So it's still our liability. Our insurance has to pay for that. And we have to make sure that we check the results of AI. And that goes similarly with the, I don't know, the HR process on hiring or firing somebody. It's the board member who is responsible for those decisions, making sure that they're legally compliant. AI can be a tool that helps them to come to the decision, but ultimately it's the person. So. And from developers' perspective, I think there was some special law in at EU level that, but I would have to look it up at the moment. Whether basically the harm done by an AI tool, I think it was strict liability, basically as product liability. So, but don't quote me on that. So, I have to check it.
Claudio?
Yeah, I'm wondering about who is liable of the output and whether is that crystal clear that those training the model won't be responsible of that. We had a case of a provider of English tests for selection of students that they are using AI to provide the scoring. We decided not to go with the contract because the data, it wasn't clear to us whether that is legal or not to provide them the data of the students. But in the selection of the students, I trust the company to do the proper, the one providing the train model that will provide the right answer. I mean, I will not, in a case of a court, I'm not gonna feel responsible that actually I took the wrong decision. So I think here probably is that, so Sandy, you are very sure that it seems that they are not responsible at all on output, right?
Well, the evaluating employees, evaluating students in educational institutions, assessing risk in insurance matters of people. Those are all high-risk systems. So, so they have to be quite. You have to be quite careful in using them. But when you do, you still need to have human at the end who verifies them before making the ultimate decision. So, and that. You're just using the system. You cannot blame the system for suggesting you something. As I said, unless the developer is happy to take on full responsibility for the ultimate decision that you take by using their system, but I don't think that will ever happen.
There's one more thing for Arturs to correct me, or at least say which paragraph this is. If it's, if I remember correctly, if it's a high-risk system, then you, as not a user, but as a buyer of the system, you are expected to know the full software supply chain, how this AI was built, what data went in, the full process. And that's something what we can't provide if we use some out of EU service. That's where Mistral from France has probably a monopoly in a way in EU. If we look at it in this way, even all these, well, llama should fall into usable, right? We can see what goes into the llama should be possible, but yeah. So that's also important, that you need to kind of, at least as per law, show what goes into it, not just, oh, it's useful, cool. It's not my fault that it showed wrong results.
I have a question rather. At what point a provider becomes a deployer? Because what is regulated is not the models, it's the systems. So if I take a Mistral model and I fine-tune it, do I become a provider rather than a deployer, or I take just the Mistral model as it is, but I add so many features that its behavior is consistently different? So that was my question for the experts.
Okay. From legal side, it's simple. If you take the model system of AI the developer developed and use it the right way, it's as instruction is says, so you're just deployer. When you change something in the system, okay, there's also another side. Providers should develop the systems that no one can change from outside anything in common sense. But if you change something or modify the system in big way, it's start working maybe somehow another way that's supposed to be. So your legal status is changed from deployer to provider.
So my question is, how do you quantify in a big way? Because realistically, no one will use these models as they are, because of course they need to fit their core business. So if I am in banking, I need to adapt to banking language, function calling for what are my internal processes and so on. So
this is a very excellent question, and I won't be able to answer that. But this is an enforcement practice. So there is this Annex 3 and ability for Commission and national authorities to issue further guidance, and this is going to be a question that will be clarified in practice, and hopefully before through some guidance as to at what point whether you change the visuals only as you are already changing the status, or you have to, when does it become material change that your status changes. So that is courts, national authorities, and so on, but hopefully in uniform way across EU, that it's not like in one country you change a little thing and you change already, and then, but it is also a problem, a possible problem that, as it was said in the morning, a lot of countries have opted, including Latvia, that supervisory authorities are multiple, like 10, and they each can have also different opinions. So it's EU level, national level, 27 member states, each having multiple authorities. So it's gonna be interesting for lawyers.
Can I add just? So before we talked about the Brussels effect and whether this will be the case also for the AI Act. So there are some doubts about it. But maybe specializing in measuring these drifts, so which are, again, emerging behaviors with respect to the regional model, could become one of the specializations of European institutions and companies. And this, I believe, is something that provides value also outside of Europe. So it's not only regulatory matter, but it's also a technical one, because once you say this is how you do it, then someone has to do it in the proper way. And so has to implement a technical assessment toolkit to do these measurements. And it's not trivial, I would say. So maybe we can also find this niche as a potential.
Quick comment. I think we can chill a little in a way that so GDPR was released which year? I forgot.
2018.
2018. Do we have nice automatic tools which you can just set up at a business and it shows you all the red, amber, green where you are and how against GDPR? I haven't seen such tool. So following on software supply chain, even for data chain, it's basically a mission impossible for even for a human because that requires deep technical expertise. So so it's not that bad.
Since we are almost exactly in the time, we have 30 seconds, and let me wrap up our discussion. Remember, I started with this economic indicator that EU today in AI world is not competitive. Remember, it is below 10%. Like me, for economy speaking, okay, EU economy should become more competitive. And we should weight, this regulatory versus business, economic development, not growth. And for this, from your takeaways, these were really nice takeaways that you told, really we have to establish clear governance model. We need to have not one sandbox, probably more sandboxes here, and find financing for this. We have to make people aware, this awareness what I got told, and I also like this thing about AI inventory, we did it 20, 30 years ago, why shouldn't we do it? It's simple, it wouldn't require such a lot of resources. And the last thing is, not the least, is this communication, two-way communication, which is very, very important. And I think by putting these veils, then we will not be talking just can we or we cannot, Now we'll talk about what we can do, to think about how do we boost EU economy with AI tools. Because understanding if we don't make this mindset, we'll lose competitiveness because AI is here today. And we have to make decisions. And by taking all these takeaways, I think we will, for sure. So, on closing this, I would say thank you for the great panelists, for the nice discussion, and thank you for attention.